appearances.
Joanne Perry for the people.
I'm Jeff Harrison. I'm here on behalf of Sarah Lane Crocker. She's next to me at the table.
Thank you. Ms. Crocker is here currently in pretrial custody. We'll go over that in just a moment.
Yeah.
Also, this morning is Mr. Brian Potter. He's an agent from the Michigan Department of Corrections who's prepared the pre-sentence investigation report. We're here today for a sentencing and a single conviction for use of methamphetamine as a second or subsequent drug offender. Ms. Crocker was on bond last Friday. The court signed a bench warrant that triggered her arrest. That bench warrant was based upon a report that the defendant had tested positive for methamphetamine on or about November 16th of this year. Make sure that is it. And there was an attempt to falsify a urine test on December 12th. That was added to the terms, the reason for the bench warrant. And allegedly there was an admission. Mr. Harrison, how would your client wish to respond to the alleged bond violation?
She tends to take responsibility for those allegations.
All right, Ms. Crocker, please raise your right hand the best you can. Do you swear or affirm the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth? You may lower your hand. Ms. Crocker, is it true that you had tested positive for methamphetamine back on November 16th? And that's because you had used or ingested or somehow all right. And also, is it true that when you appeared for testing last Friday, you failed to provide a sample from your own body and then tried to present with a bottle of either fake urine or somebody else's urine?
Yes, sir.
All right. Court finds the defendant in violation of her bond. All right. So now we're going to move to book and bond seems to be somewhat irrelevant at this point. We're going to take a look now at the pre-sentence investigation report. We do need to add some jail credit now. And so that's on CFJ 145, page 2. We're going to put an arrest date there of December 12th, and that goes through December 14th. Even though the day is the 15th, she would get credit for it if I gave her a jail sentence. We'll see what's going on. So we've got 3 days of credit. Previously, she was in custody from September 22nd through October 3rd, but she was serving another sentence on a probation violation. So there's no credit for that period of time. Ms. Carey, did the defense have any, did the people have any amendments, corrections, or objections to make to the contents of the report?
I just have, and this is more of a question on page 1 of CFJ 284A under evaluation and plan in the third paragraph. It says had passed all substance abuse testing at community corrections.
Yeah, that needs to be changed.
That needs to be changed, I believe.
Yep.
That was the only.
Okay. Mr. Harrison, any amendments, corrections, or objections to make to the contents of the report?
I don't, I'm sorry, Your Honor, I'm having some difficulty. I do not have any proposed corrections, I'm sorry.
All right, allocution then, sir.
Well, there are a couple of things that are clear. Crystal clear, abundantly clear, whatever adjective you want to put in that blank. First of all, Sarah Crocker has a problem with methamphetamine. That is, it's not even the elephant in the room. That's so obvious. It's inescapable when we talk about her situation. I think what's telling is this is not a new problem, but her level of involvement or her level of desire to participate in her own recovery is finally at the place where it will likely lead to her success. She's dealt with healing private wounds. I do have a jail letter from Carol Sheetenhill. Well, she's been in the jail to talk about finally getting to a grip on methamphetamine and making it part of her past, not part of her present. She is no angel on one hand. On the other hand, she's not unlike any number of people who come in before this court on a regular basis, who left to their own devices. Some people would say will not stop using methamphetamine. I would say cannot stop using methamphetamine. She definitely falls in that category. She requires some form of treatment, whether it's release to treatment from the jail through the MDOC, whether it's an issue that she does some jail time up front and goes of her own volition. That has to happen for her to take the next step. And the next step, quite frankly, is her staying alive. Because this, one thing you can say about the methamphetamine situation is, for the most part, it's a young person's game. Well, again, I don't want to cast too many aspersions because she's younger than me, but Sarah is no young person. She has younger friends, probably because of her high energy level and her desire to live an active lifestyle. And that's part of the problem that she's experiencing in that regard too. And when I say problem, what I really mean is a circle. It's a circle of reasoning that you convince yourself at some point that in order to participate fully in the life, you have to supplement that because reality is too difficult to handle, and et cetera, et cetera, et cetera. And that's the thinking that she's been victim of and participated in over the last several years. It's a hard thing to look at objectively and say, look, where does the person start and the addiction begin? Because really, when someone comes before the court, what you're doing is you're punishing the person. You're administering a sanction to the person for his or her own admitted behavior and actions. Courts are not equipped, nor should they be, probably, to impose a sentence upon one's addiction. I'm saying it that way on purpose because really there are two different things here, and they're all kind of balled up together, especially when you look at somebody like Sarah, who has so much to lose by participating in this. Maybe it's easier for a young person to say they don't own any significant assets, they don't have any family to support them, they don't have a significant other that will stand by them come hell or high. She has all of those things, Your Honor. So it's not necessarily just simply a choice that she's making. I understand that that doesn't jive with the provisions of the law that required her, at least in this case, to give you a factual basis for her to tell you what she did. And she did. It doesn't jive with the personal responsibility that one has to take to embark on the journey to recovery. I had an interesting conversation on Friday. I slipped off to Meyer prior to the 1:30 court session that we had on Friday. And while I was at the store, I encountered not Mrs. Crocker, but her husband. And he accompanied me throughout the rest of my travels through the store, discussing his frustration and the impact that this has had on him and his true terror at what fate awaited his wife here today. Now, all of that was a preface, Your Honor, because I realize she's 2 to 17 here. I also realize that by virtue of the fact that she just admitted to a bond violation, you now have what would be considered good cause to impose a jail sentence upon her in this matter. I don't know how to say this without just saying it, so I will. We fully expect that you'll do so. Because we're, and I mean me and Mr. Crocker, are aware of the fact that, of the reality of her situation. We would love to tell you that we have a plan to get her into rehab that hasn't been formulated yet because we were unaware of the extent of her issue. We now know. We now know that she needs to do rehab, whether it's through, like I said, MDOC or of her own volition. In doing so, Your Honor, I never know the right way to say this because I want to provide guidance to the court, but I realize the court doesn't request or need my guidance. So for lack of a better term, what I would say is I would have the court focus on the fact that this is a, if you will, amplified misdemeanor charge that we're dealing with here today. In a way, your decision would be simpler if this were the 10-year felony with which she was originally charged. It would be patently obvious what the court ought to do in that circumstance, in that situation. This, I don't believe, is that simple. I believe it's more nuanced than that, and I trust the court's discretion in that regard. Thank you.
Gary?
Thank you. Right, this is not a new problem. And now she's ready and understands her need for recovery and wants to do that. Well, she's been in jail 3 days, and 3 days ago, she falsified a urine test stating she would test positive. She used again, and then she lied about it and tried to deceive court and community corrections with a false test. The report itself, the PSI says the defendant is not a good candidate for probation, having been on probation at the time of the instant offense, having prior bond violations in the prior case, including using meth while in treatment. When she got out of jail in October on the probation violation, she didn't go into a residential rehab. She didn't go to rehab. Instead, we have her using and falsifying a test. I think Ms. Crocker has told us exactly what needs to happen in this case, and I believe it is a 1-year jail sentence. Thank you.
All right, Ms. Crocker, you have the right to make a statement if you choose to do so. Is there anything you wish to say at this time, ma'am?
Oh, Your Honor.
Okay. Well, you were on probation to this court for an identical charge. And when this happened, you were found to have meth, and you were apparently in a vehicle with felons, which is a violation of probation. Your history, criminal history, isn't overly extensive, but it's significant enough that you had faced prison sentence. If looking at, or based upon looking at your old pre-sentence investigation report from the 2024 case, that guideline was a 5 to 23, which means this one would have jumped up, and you definitely would be looking at a prison sentence. At least the guideline storage would be there. But the prosecutor decided to reduce it from a potential life offense to a potential 2-year offense, even though you were doing exactly the same thing that you were on, for which you were on bond. So, don't think I'm limited as much as people tend to think I might be. 1995, you had a conviction for violence. There was a domestic violence and an attempted R&O. Then, while you were on bond for that case, about 2 months, or looks like actually about 10 weeks later, you picked up an armed robbery case, and then you pled to unarmed robbery. You got a prison term. After getting out, you had a clean record for about 2 to 3 years. You picked up an alcohol case, so you got some substance use disorder. Then in 2003, you picked up yet another assault, although that was reduced down to a jostling. Then you get about a 10-year gap, and then you pop up in 2013, operating while intoxicated or impaired again, so more alcohol issues. Then you had a fairly good gap of about 7 years. Then you pick up a theft charge, a retail fraud here in Wexford County. And a little less than a year, about 8 months later, you pick up the meth charge, where you pick up meth, and Kent County lets you reduce that down from a 10-year felony down to a use. Looks like you got 7411, but it looks like that was dismissed. Then you've got a charge down in Charlotte, which is still pending. Maybe somebody will call in Charlotte, let you know that you're in jail. They won't, but they probably won't. It's a $500, or how many mile pickup?
I don't remember.
Yeah, they're not going to pick you up.
Yeah.
So Charlotte County doesn't seem to care about it. So I guess whatever. Then the 2023 event, which got a charge with a disposition in this court on April 29th, 2024. And in there, I gave you 36 months of probation and 9 months in jail. So on a couple different meth cases, probation hasn't worked. And jail, which last time, because of probation violations, got to 365 days. And a violation revoked, that, that didn't seem to work either. So I'm really at a loss here about what to do. Now, had you been convicted of the possession, yeah, I'd send you to prison. Because you also have violated bond here in this case. Showed up with fake urine, you test positive. And I remember your attitude from a couple different prior court sessions. It was less than impressive. And I don't see it as an acceptance. From what I remember, it seemed to be more of a blaming on everybody else. That you weren't getting enough attention or something. I don't know. You've been dealing with alcohol and cannabis, cocaine, and methamphetamine now for several years, and it's not working for you. Take a look here at the other history. Has she had any rehab since she was on that last period of probation?
Just no, Your Honor. She had gone into Pine Rest in 24 for a short period of time
Okay.
for dual, but outside of that, no, Your Honor.
All right, thank you. So I don't know what to do here, but just give me a moment. So you've had inpatient programming twice. We had the program that Mr. Potter just discussed, and you've had AA a little bit, over at least looks like a long period of time. Yet you keep going back to controlled substances. You keep putting your own health and life at risk. The court will place the defendant on a period of probation for 24 months. Again, I find that a bit silly since the law actually says I should only put people on probation when I don't think they're going to reoffend. But if you're going to reoffend, but I'll still give 24 months of probation, adopt the terms or conditions that are listed on CFJ 145, pages 2 and 3. I find that theirs are well suited for rehabilitative purposes here. Specifically, the terms or conditions dealing with alcohol, intoxicants, controlled substances, testing, inpatient treatment, outpatient treatment, and so forth. I'm very, very much concerned here for the health and safety of the defendant. And the fact that she came last week ready to give fake urine because and then she said here, according to the statement, she tested positive, or said she would test positive. I don't know what to say. It's really unfortunate. Instead of looking for help, she just keeps looking for forgiveness after knowing that she's going to keep using. One moment. The court again has already covered probation. I assess a $68 state minimum fee, a $130 crime victims' rights fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, and a supervision fee of $30 a month or $60 a month if there's any electronic monitoring. The court sentences the defendant. I find this to be reasonable apportionment based upon the other sentences she's had for meth and other issues involving whether it's alcohol, meth, or the alcohol and meth that are passed. The court sentences the defendant to 270 days of jail with a 3 days of credit. will begin to serve. If Mr. Potter is able to get you into a program, I'm willing to consider it, but you've already had a couple inpatient programs. So, all right, have I missed anything, Mr. Potter? Ms. Carey?
No, thank you.
All right, Mr. Harrison's gonna bring you 2 copies of one document. You're gonna place your initials on it. And so neither elects nor waives any rights. It merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal your conviction and sentence in this case. Then it's to be done by filing a plea with right to appeal. However, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of your copy of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. Mr. Crocker, I hope that while you're in the jail, you really take advantage of Catholic Human Services and Ms. Cox. We take a lot of effort to find funding, get the county to pay for an employee to be there to be able to provide treatment. So I hope that's what you do. I really do. We're adjourned. Thank you.
Thank you, Your Honor.
Our next